In the case of the Crown against Burgess ex parte Henry, the High Court said that in the 1930s, aviation had not yet reached the point where, in order to regulate interstate aviation, the Commonwealth would also need the incidental power of regulating all aviation. The Commonwealth was therefore limited to only regulating cross-border aviation. By the 1960s, things had changed. There was now a lot more aviation in the skies. The planes were faster and carried more people, and scheduled airlines, usually operating interstate and overseas, were common. Australia had also signed the Chicago Convention on International Civil Aviation. It was time to reconsider whether Commonwealth control should extend to all aviation. The Commonwealth passed new regulations by which it purported to require all aviation operations trading in Australia to hold a Commonwealth licence. Airlines of New South Wales, which operated between Sydney and Dubbo, had its licence cancelled under the New South Wales legislation, and it challenged that legislation on the basis that the Commonwealth was now the regulator. This gave the High Court the opportunity to reconsider whether the Commonwealth power under Section 51(1 to regulate trade and commerce with other countries and among the states now extended to regulating all aviation, on the basis that it was impossible to just regulate interstate aviation, that interstate and intrastate aviation had now become completely intertwined. Justice Menzies said it all. It needs no labouring to make the point that any aircraft in the air may be a danger to neighbouring aircraft. This is more obvious in the approaches to and over a great metropolitan aerodrome than it is in the outback. Nevertheless, in days when aircraft fly great distances at high speeds upon routes which, through weather, interference or mischance, they may not be able to keep, no one can fly safely unless all who fly are subject to a common control. A grazier who flies from station to station, a prospecting company conducting an aerial survey in areas where no other aircraft is likely to be, every charterer who flies an unusual route, every superphosphate spreader in remote and hilly country can, for instance, still put aircraft engaged in international flight at risk. Nowadays, of course, the trade and commerce power is seldom relied upon because virtually every aviation company is a corporation, and the modern, expansive interpretation of Commonwealth control over corporations does the job.